So what happens when someone passes away and they have assets in their name individually and they don't have a will? Well, folks, first of all, what happens in this instance is many people that I talk to actually believe that your stuff automatically goes to the state. Your assets automatically go to the state when you don't have a will. That's not true. There are laws in Massachusetts called the laws of intestacy, which I'll explain in a minute. But first, when a person passes away and they have assets in their name individually, the probate court must be approached. And usually it's approached by family members or close friends in order to introduce a will if there is a will. But in our instance, there is no will. So a petition must be filed, and it's usually one of two ways in general. If all of the parties, all of the heirs, all of these descendants of the person who passed away are getting along. The first way that friends, family, or petitioners can approach the court is with an informal petition. And with an informal petition, what happens is there's no judge appointed typically to the case. There's a magistrate that oversees the case and does a lot of the workings administratively. So there are no hearings down the line. And typically what happens in this instance is there is what we call a personal representative. Now, the personal representative is the term we use. It used to be what we call an administrator, or you might know it as executor of the estate. Actually, it's a little bit different. So personal representative is the term it's used for the person who manages the estate. And the court will issue what's called letters of authority once the court approves the petition or allows the petition. And that personal representative, once appointed, has the ability to deal with the assets of the estate. Now, the second way that an estate can be handled is formally. And this typically happens when the descendants, the heirs of the person who passed away are not getting along. There's disagreement, there's fighting. And so then what happens is usually what we say a person of priority, usually a family member, friend, once again, will approach the probate court with a petition. That petition will be introduced to the court, and then the court will respond with appointing a judge. There will be a notice sent from the court called a citation, and that citation basically is to give notice that something is going on inside the court with this person's estate, and that one of the interested parties is trying to get appointed as the personal representative. Now, that citation will have a date on it, and the date is when all of the other parties, any of the other parties that may not agree, can file an opposition to the appointment of the person who approached the court. And so that citation has to be served on all the interested parties, and the citation has to be published in one of the local newspapers. And this will give the parties of interest or at interest the ability to respond, because they'll be on notice at that point. So that's the second way that an estate can be filed in the probate court. Now, back to our question. What happens when someone passes away with assets in their name and they don't have a will? Well, you can think of title to assets like a person that needs to belong somewhere. And this person's going to ride a roller coaster. So first what happens with your assets, with the title to your assets, is it goes down your descendants, basically your bloodline, to your children, looks for a spouse, to your children. If there are no children, if there is no spouse, it goes back up the roller coaster, up a little bit higher, to see if the parents are alive. If the parents of the person who passed away are not alive, then it'll come back down and look to the siblings of the person who passed away. And it will spread out at that point. If there are siblings that are alive, then title will split into those siblings. And if those siblings are not alive, then it will go to the nieces and nephews of the person who passed away. Now, if there's no siblings, no nieces and nephews, then it'll go up a little bit higher to the grandparents and to their siblings. And basically what happens is the laws of intestacy will look for folks in the bloodline that are alive that will be entitled to receive their proportionate share of the interest in the estate. So that's what happens when a person passes away without a will. It doesn't, what we say, escheat, doesn't go to the state. It first has to go through, the assets first have to go through the laws of intestacy. And then the heirs of the estate are sought out. Now, if you are watching me on YouTube, make sure you subscribe in the lower right-hand corner. And some of my other videos will be appearing here, and they'll be related to this topic that we talked about. If you're watching me on Facebook, make sure you like the video. Now, I have included links to some of my past videos inside the description. If you're on YouTube, it's going to be down below. If you're on Facebook, a lot of times it will be above. And there'll be links to my prior videos that are related to this particular topic. So make sure you check those out as well too. Dave Ceruolo, ceruololaw.com.